Up the case of people in the state of Michigan versus Crystal K. West. There are 4 case numbers here: 25-3646, 3647, 3648, and 3649. All FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Missaukee County.
Please call Rob Chappie, appearing on behalf of Crystal West. She is seated to my left.
All right, thank you very much. All right, so I have got a written pre-trial agreement here, and I'm going to summarize it. See if I've got it correct. Okay. Looks like out of the 4 cases, if the defendant enters a plea of guilty to, or no contest, is that what it's still would be?
No contest, Your Honor, yes.
No contest to 2 counts of assault, resist, obstructive police officer in file 3649. The people agree that there would be a delay. Is that a Killebrew?
Yes, Your Honor.
That there would be a Killebrew agreement that at the time of sentencing, the defendant would be placed upon a delay if she has no further or no violations. And then at the end of the delay, if she is successful during that period of the delay, the charge can be reduced to is it to a single attempt assault resist?
2 attempts, Your Honor.
All right. So we're gonna put 2 attempt resist an officer. And it says something else, but I can't read it. It says
restitution for all cases.
All right, all cases. Thank you. And if the court complies, then at that time of sentencing, hold on. There's also an agreement that the 4th habitual felony offender enhancement would be dismissed.
Correct.
Yes.
Then after that, if that's what happens in file 3649, the remaining counts 3646, 3647, and 3648 will all be dismissed. Is that correct?
Yes, Your Honor.
Mr. Champion?
That is a correct statement, Your Honor.
Okay. Now the next thing is, as I talked about earlier today, this Killebrew agreement does not apply to fines and costs. Those will can still be assessed by the court and then therefore not violate the agreement. Is that correct, Mr. Ringstrom?
That is correct, Your Honor.
That is a correct statement, Your Honor.
All
We'll discuss that and the fact that restitution would be.
Right, good, thank you. All right, Ms. West, is that how you wish to resolve this?
Yes.
Please raise your hand. You swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth.
Yes.
You may lower your hand. I forgot to state that today we're on the record for a status conference, and that's because of the number of cases. And I don't remember why we were in the court a couple weeks
Your Honor,
ago.
we're required under status conference because legal insanity defense had
Yes.
been brought before the court. The court had made that order to allow it. That did not happen. So that was partly
Oh,
why.
I didn't send it for.
No, Your Honor.
Yeah, okay, good. That's all I need to know. And we didn't have a competency order either.
We had a competency in this case to begin with. Originally, she was found to be not competent, but then she was competent
Yes,
later.
all right. Thank you. Any further issue and discussion need to be done on the record about that, Mr. Champion?
No, Your Honor.
All right, good. So, Ms. West, back on April 25th of last year, were you on probation or parole?
No.
Were you on bond pending any felony charges at that time?
No.
All right. I have to go over all these charges, even though a lot of them are most of them are gonna be dismissed. I still have to go over them. All right, so if I go over too much or you get lost or need me to repeat something, just raise your hand. I'll ask you what you need. You can just say, Judge, could you please repeat that? Okay. But you go to remain. All right, one more. In file 25-3646 FH, Ms. West, you are charged with 3 counts. And there's a sentencing enhancement. Counts 1, 2, and 3 are all charges of assault, resist, obstruct a police officer in the performance of his or her lawful duties. Each one of those is a felony punishable by up to 2 years and or up to $2,000. And because there's a 4th habitual felony enhancement, if at the time of sentencing, the court could, if there was a sentencing, the court could, within its discretion, increase that potential punishment from up to 2 years to up to 15 years. However, part of your deal is that entire file will be dismissed. Now, for your memory, that involves a date of March 29th of 2025. In file 3647, you are charged with 2 counts of assault, resist, obstruct a police officer, which again are felonies punishable by up to 2 years and or up to $2,000. And because of another 4th habitual felony enhancement, those could be increased from up to 2 years to up to 15 years within the discretion of the court. And you were also charged in that file with another count of domestic violence. That is a misdemeanor punishable by up to 93 days and or up to $500. However, that entire file and its charges will be dismissed. Do you have any questions about that?
No.
Okay. Next file is file 3648. In this file, you're charged with 3 counts of assault, resist, obstruct a police officer, and with a 4th habitual felony enhancement. That means that each one of those 3 counts carries with it they are felonies. Hold on. Each one of those are felonies punishable by up to 2 years and or up to $2,000. Plus, as with a 4th habitual felony enhancement, each one of those could have a punishment increased within the discretion of the court from up to 2 years to up to 15 years. Now, there's another thing that's really important there is that 2 of those charges involve corrections officers at the Missaukee County Jail. Now, that's important because also within the discretion of the court can make the sentencing concurrent or consecutive. That means that in that particular file, if you were convicted of 3 and with a 4th habitual enhancement, count 1, I could give you, say, for example, 5 years. You'd have to serve that before you'd serve the 5 years on the next count. And before you'd serve the 5 years in the other count, because they can be made to run consecutively. So that's a big deal. However, if you enter the plea in the very next file that I'm about to talk about, that will all be dismissed. Any questions so far?
No.
Thank you. Now, in file 3649, here you are charged again with 2 counts of assault, resist, obstruct a police officer. Each one of those are felonies, once again, punishable by up to 2 years and up to $2,000. Plus, as a 4th habitual felony enhancement, they could be increased from up to 2 years to up to 15 years. Now, these also appear to involve corrections officers, which means that within the discretion of the court, the sentence could be ordered to run consecutive. So once again, if you were convicted at a trial, and therefore the maximum punishments would both be up to 15 years, and if I gave you 2 years for one and 2 years for the other, you'd have to serve a total of 4 years if I so ordered it. You understand?
Yeah.
All right. Now, that's not likely to happen here because there's an agreement if I go along with that agreement. I'm told today that you're gonna plead guilty to counts 1,
No contest.
no contest, thank you. No contest to counts 1 and 2. Then, if I accept that plea, then we'll come back for sentencing. And at the time of sentencing, I'll dismiss all those other files and put you on a delay of sentence for up to a year. Now, that delay is not probation, but there are terms or conditions during that 12-month delay that are very much like probation. I'll order that you can't possess or consume alcohol or controlled substances or marijuana, things like that. I'll order that if you have to go to a treatment program, you might have to go. You'll be subject to random testing and other terms or conditions that are a lot like probation. Then, if that's what I do, and you complete that period successfully, when we come back here for the actual sentencing, so in other words, I don't make the sentence final. If you are successful, then the prosecutor agrees to allow you to withdraw your plea and then enter a plea of no contest to lesser charges. Now, those two lesser charges are attempt to assault, resist, obstruct a police officer. That means instead of being punishable by up to 2 years, it would be up to 1 year. Technically, they could also be ordered to run consecutively. But I don't foresee the prosecutor asking that, but that's going to be a decision up to me. All right. Do you have any questions?
No.
All right. Now, there's this word we've talked about regarding the sentencing that's important for me to ensure that you understand. That word is Killebrew. Now, Killebrew is just the name of somebody who had an appellate case somewhere in the appellate courts here in Michigan, and it says this: you have reached an agreement with the prosecutor, and that agreement is all those charges will be dismissed, and you'll get this benefit of the delay that I just discussed at the time of sentencing. Now, if I don't go along with it, and I don't know why I would or wouldn't, I don't know anything about it. I know we had a hearing a couple weeks ago, but don't really know anything else about you. But if I don't go along with it, you would have the right to withdraw your plea and come back to the same stage of the proceedings. Okay?
Okay.
Now, if I do go along with it and I place you on the delay, then you're stuck with the deal. Okay?
Okay.
Now, that means that if you violate the deal during that delay of sentence, I could choose not to let you reduce the charges. Okay, you understand? So the whole key is step one, do I put you on the delay when we come back in about 4 weeks? And then step two, if I do, are you compliant? Because if you're not compliant, then the convictions to the 2-year felonies become permanent. Do you understand that?
Yes.
Do you have any questions about this pretrial agreement? It's fairly complex, so I just want to see if you have any questions.
No.
All right, good. All right, now, if you enter the plea of no contest that we've talked about, you're not going to have a trial. Does that make sense?
Yes.
Now, I've got a couple pieces of paper here provided to me by the attorneys. The first one is 2 pages long, and it says plea agreement at the top. And I turn it around, it looks like it's got your signature there. Is that your signature?
Yes.
And did you talk about this agreement with Mr. Champion before you signed it?
Yes.
Did he go over the evidence against you?
Yes.
Did you talk about all the options that you had, whether to go to trial, do a plea agreement, things like that?
Yes.
And has he answered all your questions?
Yes.
All right. So far, are you satisfied with his advice?
Yes.
All right, good. Now, do you believe while entering this plea may not be the most wonderful thing to do on a Monday morning after Easter, but do you believe that entering this plea is in your best choice considering all the other options?
Yes.
All right, good. Now, if you enter these pleas and I accept them, we're not going to have a trial. Do you understand that?
Yes.
The second piece of paper I'm holding up here says advice of rights. So if you enter a plea and I accept that plea, you're going to be given up certain rights. Now, this piece of paper also has your signature. Is that your signature?
Yes.
Did you read through all these rights before placing your signature there?
Yes.
Did you understand all the words that you read?
yes,
And even more importantly, you understand that if you enter a plea of guilty and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
yes,
Now, also, if the plea is accepted, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Do you understand?
yes,
Have there been any other promises, threats, or inducements to get you to plead guilty or not contest, no contest, that we haven't talked about?
no,
Okay. Is there anything else you think I should know about how you got to this step?
no,
All right, thank you. 1 second. The last thing I need to talk to you about before I take the plea is about what a no contest plea means. No contest plea has the same impact as a guilty plea. The difference is, instead of requiring you to state on the record what you did that makes you guilty of these two offenses, I'm going to look at something else like a police report. Do you understand?
okay,
And is that what I'm looking at?
Yes.
All right. Also, I can do this in only a few certain situations. What's my reasoning today?
Your Honor, due to her mental state, she has no memory of the incident.
All right.
And potential civil liability.
Potential civil liability against the corrections officers. Were there any injuries sustained?
There was potentially some injuries, restitution, we have to look into a little bit more, but the restitution request would be due to sick leave.
Okay. And Mr. Champion, when you remember, we talked about the lack of memory. I understand that there have been some issues about criminal responsibility and competency to stand trial based upon your experience of working with, you worked with Ms. West throughout the entire processing.
I have, Your Honor.
Okay, and you don't feel like there's any need to pursue the criminal responsibility any further?
Nothing further at this time, Your Honor. It would be in her best interest to proceed in this
All
fashion.
right, good enough, thank you. All right. I think I covered it all, hold on. Oh, whatever's inside that report, I get to take as fact in establishing the plea. Do you understand that?
yes,
And that's kind of important. That means you can't come back later on and say, well, that's not what happened. Do you understand?
yes,
All right, there's two reasons why you can't. One, because I just told you you can't, and that's what the requirement is for a no contest plea. But also, based upon what Mr. Champions told me, you don't have much of a memory about it. Therefore, there's no way you can come back and say that's not what happened. You understand that?
yes,
If you do, then we've got other issues. All right. Do you have any questions of me before I ask for your plea?
no,
All right. Now, again, I anticipate that your plea is going to say the words no contest. That's not me telling you what to say, but because people watch television and movies, all they ever hear is guilty or not guilty. So I just need to make sure you understand that what we talked about today is a no contest plea. In file 3649 that we discussed today, as to counts 1 and 2, how do you plead?
no contest,
All right, good, thank you. Mr. Rickstrom is going to hand to me something that I'm going to take into look and take into consideration. And it's going to be marked here as plaintiff's exhibit 1.
Yes, Your Honor, it has been already marked. It is incident number 25-000806-157 from the Missaukee County Sheriff's Office.
Thank you. Mr. Champion, any objection to the admissibility of this exhibit?
None, Your Honor.
Thank you. People's exhibit number 1 is hereby admitted. And again, it's stated by Mr. Rickstrom. It is a Missaukee County Sheriff Incident Report for the date of April 25th of 2025. The incident number is 25-806-157. That is the same date for the felony information alleging that the event occurred on April 25th, 2025, here in the city of Lake City and the county of Missaukee. Already on page 1, I see that there is the address on the date required. And specifically, the venue here is at what Missaukee County Jail. The court also notes as listed as the victims in the case. The court takes notice are corrections officers here in the Missaukee County Jail. All right, one moment. I see beginning on page 2 of 4, again, this report's only 4 pages long. It talks about how Miss West began to assault the officers. Looks like we have Officer Lar and then Officer Reister, Reister. And also it describes in his photographs of injuries sustained by those officers. Mr. Ringstrom, do you believe the interests of justice do not require the defendant to recite a factual basis and the taking of a no contest plea is appropriate?
Yes, I do.
Mr. Champion, do you agree?
I do, Your Honor.
Mr. Ringstrom, are you aware of any other promises, threats, or inducements? Mr. Ringstrom, Mr. Champion,
I'm aware of none, Your Honor.
and Mr. Ringstrom, believe the court's complies with scroll 6.302,
Yes,
and Mr. Champion.
I believe the court has, Your Honor.
And one last one, Mr. Ringstrom, do you believe the facts stated in People's Exhibit number 1, which has been admitted, satisfy the required elements of proof for counts 1 and 2?
I do.
Mr. Champion.
I do also, Your Honor.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained inside People's Exhibit number 1 satisfied the required elements of proof. The court further finds that the interests of justice do not require the defendant to recite a factual basis for the reasons already stated on the record. Therefore, the defendant is found guilty of counts 1 and 2 and file 25-3649FH. At the time of sentencing, the enhancements will be dismissed and the other charges and the other cases will all be dismissed. Ms. West, we're going to be back in about 4 weeks for sentencing. Between now and then, a pre-sentence investigation report must be prepared by an agent from the Michigan Department of Corrections. And that report's going to include a description of the offense, description of the pretrial agreement, any statements, information you make or provide, as well as information about any prior criminal history you have, performances on bond, performance on probation. There are 3 steps that involve you. Number 1, you're going to get a packet, you're going to complete it and turn it in. You're going to get that before you leave today. You don't need to turn it in today, though. Next, they're going to have an interview with you, and you have the right to have your attorney present during that interview. And number 3, Mr. Champion needs to make sure he knows where you are so he can reach you and tell you when you need to be back here to court, but also because he needs to go over the contents of the report prior to coming here for sentencing. Each side has the right to make objections or request corrections to the report. Do you understand?
Yes.
There's one other question I forgot to ask you earlier. I know Mr. Champion talked to you about potential sentencing guidelines, things like that. The key question that I have for you is, has anyone promised you exactly what I'm going to do?
No.
All right, good. Thank you. Anything further today? I'm sorry, Mr. Richard, any objections to the continuation of bond?
No objections.
Bond hereby continues. Anything further, Mr. Ringstrom?
No, yeah.
Anything further, Mr. Champion?
No, Your Honor, thank you.
Ms. West, any questions about what we have done today or what's going to happen next?
No, thank you.
All right, good. Thank you. We'll see you in about a month. We are adjourned.